Chapter 8 Transfer and Transmission of Share. Introduction. Partnership firm came into existence due to limitations of sole proprietorship and limitations of partnership firm have given birth to company formation. When partners separate in a partnership firm, the procedure is long and complex. In a company, no such procedure is required. In a public company, if the shareholder sells his share, his ownership ends. Shares can be freely sold or purchased just like any product. Free transferability of shares is an important characteristic of a company. Not only that, if a person wants to purchase shares of the same company, again he can purchase the share and he can be owner of that portion. This right is absolute right which cannot be prohibited by the company. A shareholder can voluntarily transfer his share as per provisions of the Companies Act. Moreover, when shares are compulsorily transferred by operation of law, then such transfer of share is called transmission of share. In this chapter, we will learn about share transfer and transmission. 1. Meaning of share transfer. In a general sense, share transfer is the act in which a shareholder voluntarily sells his share to another, waiving his right to ownership and transferring the title of share in name of the other. Definition. When a shareholder, in anticipation of approval by company, voluntarily waives his title, that is ownership right, of shares in favor of other person or persons, and when there is a transfer of title, that is ownership to the shares, it is called transfer of shares. When a shareholder sells his own share to others or waives his right, then his ownership or membership is over and the person who has purchased obtains membership or ownership. Here, one thing should be noted that this procedure is treated to be complete only when transfer is approved by the company. 2. Importance of share transfer. Share transfer is an important procedure. Shareholder use their right to transfer shares with the consent of the company. Share is a part of capital of a company. It is a financial interest of a shareholder. It is a movable asset for shareholders. Shareholder has a right to sell, right to gift, and right to lease his shares. For this, Lord Blackburn has said, main objective to start joint stock company is to provide easy transfer of shares to their members. Purchase and sale of share is conducted in the share market. This is a source of capital, so it is known as the barometer of the development of a country. 1. Share transfer generates income for the government. Share transfers increase leads to increase in the government's income because the government has imposed tax on it. 2. Shareholders get cash on sale of shares. 3. Purchaser of shares gets rights of ownership. 4. Shareholder is able to get benefit of market variation. 5. Invested funds of inefficient units flow to efficient units. 6. Share market and capital market grow as a result of share transfer. 7. Free share transfer leads to an increased span and scope of the development of a company. A provision for transfer is specified in the Articles of Association. Sometimes there may be restriction in private company, but the right of a shareholder cannot be taken away by imposing prohibition on it. A member can, when he wishes, sell or gift his share to others. Provisions regarding transfer of shares. Before learning this topic, it is essential to know that the types of shares that can be held by shareholders. From the point of view of share transfer, shares are of two types. 1. Physical shares. 2. Demat shares. 1. Physical shares. In this format, share certificate with the shareholder is issued by the company in physical form. This share certificate has the name of the company, shareholder's name, share certificate number and value of the share, company seal and other necessary information on it. There are possibilities of it getting torn, stolen, getting destroyed in fire, and of being physically destroyed. 2. Demat shares. Dematerialized shares are known as demat shares. This type of share is not with shareholder physically, but is in a demat account opened by the shareholder. You have already studied in class 11 regarding demat account. This type of share has no fear of getting lost, torn, being forged, or being destroyed in fire. The procedure for transfer is different for physical shares and demat shares. A share transfer procedure for a physical share is as under. Company may refuse to transfer shares if procedure is not followed satisfactorily. 1. Share transfer form. To transfer the share, a prescribed form has to be filled up properly. This form contains complete details of the seller and the purchaser, like name, address, and signature. Such forms are usually available at the company registrar's office, authorized share brokers, share market, etc. 2. Share certificate. Share certificate or share allotment letter is to be enclosed along with share transfer form. 3. Unpaid calls. There should be no unpaid calls on shares that are to be transferred. 4. Objection application. There should be no objection by anybody for restricting transfer of shares. If any objection is raised by anybody, share transfer will not be granted by the company. 5. Satisfactory evidence. If a share transfer form which is duly filled and signed is lost, then application should be made, duly signed by both the parties, to the company. They have to make a satisfactory clarification to the directors of the company. 6. Lion rights. If the company has a lion right on transferee share, can approve transfer to collect its debt. 7. Stamp duty. Proper stamp duty should be affixed on share transfer form as per the market value of the share. If the stamp duty affixed is as less value, director of company may refuse to transfer the share. 8. Share certificate to the new shareholder. On approval of share transfer, the company sends changed share certificate to the new shareholder within 1 month. 9. Rejection of share transfer. Share transfer can be rejected in case registrar of company has put a restriction or court of law has given a verdict of no transfer on those shares. 10. Provision of Articles of Association. For the share transfer, provisions of the Companies Act as well as provisions of Articles of Association should be followed. If they are not followed, share transfer is not granted. 11. Register of members. Original shareholder's name is continued up to the completion of share transfer procedure. 12. Right of dividend. In case transmission is not completed, expired member or insolvent member is entitled to get dividend. 13. In case of single person company. 1. On the death of the sole member, the person nominated by such a member shall be the person recognized by the company as having title to all the share or shares of the member. 2. The nominee should be informed of such an event by the board of directors of the company. 3. Such a nominee shall be entitled to the same dividends and other rights and liabilities to which such sole member of the company was entitled or liable. 4. On becoming member, such nominee can nominate any other person subject to a written consent by that person. 4. Procedure of physical share transfer. Share transfer procedure can be divided into 2 types according to the type of share. 1. Transfer of physical shares. 2. Transfer of dematerialized shares. Procedure of physical share transfer. Procedure for total share transfer. When shareholder transfers all his shares in favor of other person, then the procedure to be followed is as under. 1. Obtaining share transfer form. The person who wants to transfer his share has to obtain a transfer form, that is, transfer instruments, duly signed and sealed by company registrar. 2. Filling up the details in the transfer forms. In a share transfer form, full details regarding share buyer and share seller are to be mentioned, such as name, address, name of the shareholding company, market value of the share, share certificate number, etc. According to the provisions, necessary stamp duty should be affixed and signed in presence of a witness. The witness has to fill his name, address, and business, etc. also. 3. Submission of transfer instrument and share certificate. The purchaser of share himself or through share brokers delivers the completed transfer form along with share certificate to the registered office of the company. A letter of allotment is enclosed if no share has been issued. Transfer can also be executed in cases other than a sale, example, in case of a gift to someone. However, the procedure followed is the same. 4. Sending the transfer receipt. On receiving the transfer instruments along with the share certificate, the company secretary issues a receipt for the same. This transfer receipt is the evidence of submission of documents of transfer. 5. To inform regarding transfer by notice. After receiving share transfer form and share certificate, the company verifies transfer instruments and share certificate. After that, the company informs both the parties through a notice. Blank or forged transfer can be avoided by such a notice. If any party has objection, they are asked to inform within 2 weeks. If no objection is received from either party, it is assumed that the transfer is acceptable to both parties. 6. Recording in the share transfer register. After surviving notice to both the parties, if no application for an objection has been received from either the transferor or transferee, then it is assumed there is consent of both parties and the transfer is registered by the secretary in the share transfer register. The name of the transferee is entered into the share transfer register. 7. Resolution for approval of transfer of shares. After receiving share transfer applications, a meeting of the board of directors is convened by the secretary in which discussions are made regarding the applications received for transfer of shares. In this meeting, a resolution is passed approving the transfer of shares which are sanctioned. 8. Entering in the register of members. After passing the resolution of transfer of shares, the names of the transferor is deleted from the register of members and that of transferee is added. 9. Sending share certificate to the new shareholder. After passing the resolution of transfer of shares, the secretary writes the name of the new shareholder on the back of the share certificate and sends the same with the signature of responsible officer to the new shareholder. If share certificate is too old or there is no space to enter the name, then a new certificate is prepared and delivered to him. Procedure for partial share transfer. When a shareholder wants to transfer some of his share from his total holding, then he has to split his share. For the split, shareholder has to send his share to the registered office of company. The company secretary split the share as per requirement of shareholder and sends it back. After that, the shareholder sells his share according to his requirement as per the above procedure. Procedure for transfer of dematerialized shares. A shareholder may keep his share in physical form, but according to new provision, he cannot sell his share in physical form. If he wants to sell his share, he has to go for dematerialized process. Demat share means to convert physical share into electronic form in a specified way. The investor has to open a demat account with a depository participant. In India, as a depository participant, National Securities Depository Limited, that is NSDL, or Central Depository Service India Limited, that is CDSL, are functioning as an agent for deposit caretaker. On behalf of these institutions, PSU banks or private bank and other financial institutions open demat accounts. After opening this account, the said institution provides an instruction slip to account holder. It is used by the account holder for purchase or sale of securities. The company can observe its shareholders and their holdings on website provided by NSDL or CDSL. However, the company cannot make any changes in it. A person who wants to purchase share has to pay the price of the share and stamp duty along with brokerage. The total amount of purchase is debited from his account and purchased shares are credited into his account. That is, shares are increased in shareholder's account. Similarly, if shareholder sells his shares, the amount of the sale after deducting brokerage, tax and other charges is deposited to his bank account and the shares sold are debited to his demat account. Shares are decreased in his account. Thus, shares are credited or debited to a person's demat account. It is important to note that when shares are purchased or sold in this way, the company has no control over it. Company has nothing to do with it. The whole procedure is done by the institution which functions as agent of NSDL or CDSL. The company can only observe its newcomer shareholder and outgoing shareholders on the web page. 5. Duties of the Secretary for share transfer. Transfer of share is a transfer of ownership. The Secretary has to perform his duty properly. He has to look after the transfer of physical share. There should be no litigation in future, nor should the provisions of the Companies Act 2013 be ignored. If such provisions are ignored, then Secretary and other responsible persons found guilty can be punished. 1. To verify share instruments or transfer form. Secretary has to verify share instruments carefully. He has to verify the number of shares, type of share, signature of shareholder, and other essential details as per provisions. 2. Stamp and fees. Secretary has to verify market value of the share mentioned in the share transfer form. He has also verified whether the stamp duty affixed by shareholders is according to the value of the share. 3. Signature of witness. Signature of witness is essential. Secretary has to see and ensure the signature of witness. 4. Receipt of share transfer. After receiving share transfer form or instrument at the company's registered office, a receipt shall be issued provided all details are satisfactory. 5. Resolution of Board of Directors. If information provided in the transfer form is found to be satisfactory and correct, then share transfer is approved. A resolution regarding approval of share transfer is passed in the Board of Directors meeting. 6. Entry in share transfer register. After granting share transfer, necessary entry is to be made by Secretary regarding share transfer. 7. Registration in Register of Members. Share transfer is approved on the basis of the form of transfer presented by the shareholder. It is followed by the necessary entries in the Register of Members. 8. To issue notice regarding approval of share transfer. After approval of share transfer, notice is issued to share purchaser and share buyer. 9. To prepare share certificate. After the approval of share transfer, it is a duty of Secretary to prepare new share certificate for the new shareholder. 10. To issue share certificate to new shareholder. After the new share certificate is prepared, new shareholder is informed to collect the share certificate as per the receipt issued earlier. The share certificate can also be dispatched to the address as per the receipt. 11. To observe the provisions of Articles of Association. The Secretary has to confirm himself that no provisions of Articles of Association have been violated in this transfer. 6. Transmission of share, that is, transfer of share under the operation of law or compulsory transfer of share. When the ownership of share is transferred compulsorily under any law, then such a transfer is known as transmission of share, that is, compulsory transfer of shares. Meaning, when the title in shares of a person is automatically transferred, it is called transmission of shares. Shares are to be transferred under the operation of law when the shareholders is declared to be of unsound mind or declared to be insolvent or in case of his death. Circumstances for transfer of share under the operation of law. 1. Will is not prepared, that is intestate, and there are legal successors. Sometimes shareholder has not prepared will, that is intestate, and he expires, then the shares in his name are transferred to successor on the basis of the succession certificate. 2. Will is not prepared, that is intestate, and there are no logical successors. Many a times, shareholder has not prepared a will, that is intestate, and he has no successor and he expires. In this situation, the court may appoint administrator, that is receiver, who then has the right to conduct the court, may appoint administrator, that is receiver. Then receiver may transfer the shares in his name. 3. Shareholder declared to be insolvent. When shareholder is declared to be insolvent by court, an official receiver or assignee is appointed by court. The shares are transferred the name of the official or receiver. For this, the receiver has to present an appointment letter given by the court. 4. Shareholder declared to be lunatic. When a shareholder is declared to be lunatic, that is, of unsound mind, a guardian or trustee is appointed by the court. Such a guardian or trustee presents the appointment letter issued by court to the company. After receiving such a letter, the shares are transferred to the name of this administrator. 5. Death of a person in case of single person company. On the death of the sole matter, the person nominated by such member shall be recognized by the company, and the company will transfer all the shares of that member. A legal representative has the right to get dividend and other privileges. However, such a representative cannot participate in meeting of the company. He cannot utilize rights which are given to shareholder. Procedure of transmission of shares. Procedure for transmission is as below. 1. Information to the company. A. Intimation about death. 1. Legal successor of the shareholder have to inform the company about the death of shareholder. 2. First shareholder is deceased. In case of joint shareholding, other shareholder or shareholders have to inform the company and produce the death certificate. B. Intimation about insolvency. When a shareholder is declared insolvent, the company has to be informed by receiver appointed by court. C. Intimation regarding lunatics or unsound mind. Whenever a shareholder is declared a lunatic by court, his guardian or trustee is appointed by court. The guardian or trustee should inform the company. 2. Verification of ownership documents. Whenever a company is informed about death, insolvency, lunacy, all the legal documents and authenticity have to be verified by the company. 3. Notice issued by company to the representative. If the company is satisfied with the documents, authority letter, verdict of the court received from the receiver or trustee or legal heirs, it issues a notice to such representatives. 4. Resolution of Board of Directors. After receiving the reply of notice, Board of Directors transfer the shares to the name of the legal representatives and pass a resolution. After passing such a resolution, necessary entry is made in the share transfer register. 5. To issue new share certificate and enter name in register of members. After the resolution of share transmission, the new member's name is entered into register of members. The new shareholder, that is, or representative, are informed to collect the new share certificate. Difference between share transfer and share transmission. Number 1. Points. Meaning. Transfer of share. When a shareholder voluntarily passes ownership of share to another person in accordance with the provisions of Companies Act and Articles of Association, it is called transfer of share. Transmission of share. When a shareholder dies or he is declared by the court to be an insolvent or lunatic, then such compulsory transfer of share under the law is called transmission of share. Number 2. Points. Circumstances. Transfer of share. It is a voluntary transfer. Shareholder may transfer share or shares at any time according to provisions of Companies Act. Transmission of share. In case of death, insolvency or person being declared lunatics, death case of a in single person company, transmission of shares takes place. Number 3. Points. Consent. Transfer of share. In voluntary transfer, consent of both parties is essential. Transmission of share. In transmission of share, consent of both parties is not necessary or possible. Number 4. Points. Consideration. Transfer of share. Share transfer arises due to a valid agreement of two parties, so consideration is essential. Transmission of share. In transmission of shares, shareholder loses ownership and ownership is shifted to legal representative. This is not selling, so there is no consideration. Number 5. Points. Stamp duty. Transfer of share. In a share transfer, stamp duty is necessary according to prevailing law. If the stamp duty is not affixed as per law, share transfer is not valid in physical shares. Transmission of shares. In a transmission of share, there is no consideration, so stamp duty is not essential. 6. Points. Membership. Transfer of share. Membership is obtained by the transferee after the approval of the Board of Directors and his name is entered into the register of member. Transmission of shares. Legal representative is entitled to the rights of a member and can claim dividend. 7. Points. Procedure. Transfer of share. A procedure of the Board of Directors is required following the provisions of Articles of Association. Transmission of shares. Legal representative sends evidences supporting his rights obtained through court to the company for getting his name registered as member. Number 8. Points. Refusal. Transfer of share. Board of Directors may refuse to transfer of shares if such refusal is in the interest of the company. Transmission of shares. Generally, the directors of the company cannot refuse transmission of shares. Number 9. Points. Responsibility. Transfer of share. The original shareholder does not have any responsibility after transfer of shares is complete. Transmission of shares. In transmission of shares, there is no personal responsibility of the representative. However, he has to accept responsibility arising due to shares. Number 10. Points. Right to go to a tribunal. Transfer of share. If a company refuses to transfer without valid reason, the shareholder has the right to go to a tribunal. Transmission of shares. The company cannot refuse transmission and so the question of going to tribunal does not arise.